My lady, if it pleases this honourable court, I am Afiqah Syahirah Muhammad Saleh, with my learned counsel Syaza Danisha representing the appellant Emma Cruella Stone. On the side of the respondent, the senior counsel is represented by Khairushazwina, while Fathin Nur Syafifah will be representing as the junior counsel. From the appellant's side, we have two grounds of contention to present in our submission today. Firstly, the respondent had been negligent for the failure to exercise his reasonable care as a doctor by performing an inaccurate diagnosis of Emma Cruella Stone's conditions, which caused her to undergo unnecessary treatment and injuries. Secondly, Dr. Stephen Strange had been negligent in treating the appellant and had caused her to suffer from significant psychiatric illness. It can and should be reasonably foreseen by the respondent that his actions would be likely to cause nervous shock to the appellant, who experienced a gravely traumatic event or is traumatically enmeshed by it. I shall require 15 minutes of the court's time for my submission, while my learned counsel will require another 15 minutes. Before I proceed, does the court require the brief statement of facts?
No need, thank you.
Much obliged, my lady. My lady, first and foremost, I would like to emphasize that the issue on the first ground would be on the case of medical negligence. I would like to raise my first submission as the respondent had been negligent by breaching his duty of care to the appellant with the practice of inaccurate diagnosis towards the appellant. Generally, standard of care can be defined as a level of attentiveness and care that a certain person owes to another person under the circumstances. This means that it includes the professional standard of care.
Also,
Yes,
can
my
you
lady.
please explain to me what is a doctor's duty of care and standard of care?
Much obliged, my lady. In regards to your questions, the duty of care would be explained when a doctor owes a duty of care towards a patient. This means that he is now potentially liable in negligence. Moving on to the standard of care in medical negligence. The standard of care in the medical negligence was started from the principle derived in the case of Bolam and Friend Hospital Management Committee, whereby the test used is the standard ordinary skilled man exercising and professing the skill. Doctor knows best is the approach used in this case. However, it does not mean that the doctor will have the absolute and discretion power to exonerate his own liability. In order to determine if the doctor has breached the standard of care, Bolam test should be applied, whereby a doctor is not guilty if he has acted accordance with a practice accepted by a responsible body of medical skilled men in the same field. This will be done by taking into account the views of responsible body of medical opinion. Should the conduct or omissions of the doctor in question conform the standard practice in the medical field, the doctor in question will not be held liable for negligence and vice versa. That being said, the medical professionals or their patients a duty of care that is aligned with the medical standard of care, which is typically defined as the level and type of care that are reasonably competent in the same medical community. It means that medical negligence should be depending on the medical judgment and not for the court to decide the reasonable practice of a doctor. This can also be considered as a traditional approach to ensure that doctors are not treating their patients with a sword hanging over their heads. In the instant case, the respondent, Dr. Strange, hold a position as a doctor that treats the appellant. He had advised the appellant to stay calm from the very moment the appellant got a virtual consultation via Zoom call from Dr. Strange. This indicates that the appellant had relied to the respondent fully about her conditions. This also shows that there was a duty of care from the respondent to the appellant on the duty to advise, diagnosis, and also the treatment. However,
The Bolam
yes, my
test places a fairly high threshold for a plaintiff to cross in an action for medical negligence, and if the law played two interventionists a role in the field of medical negligence, it will lead to the practice of defensive medicine. So how do we maintain a fair balance between law and medicine in the best interest, especially of the patient, whilst giving full encouragement and support to a properly regulated and competent medical profession?
Much obliged, my lady. In answering to the questions, I think that we shall relate to the issue here is whether the Bolam test is been accepted fully in Malaysia principle, and whether this Bolam test is applicable in the later cases. So, in Malaysia, the Bolam test applied to the standard of care is related to any diagnosis or treatment given by the doctor to the patient. However, it is also subjected to the qualification, as in the case of Bolito and City and Hackney Health Authority, which is that the body of medical opinion must resist logical analysis. The Bolito test should be an expansion of the Bolam test in order to balancing between the law and medicine in the best interest of patient without neglecting the support to a properly regulated and competent medical profession. In Bolito test, it requires the court to consider the logic and also the reasonableness of conflicting medical opinions. This means that a doctor will not escape liability for the negligence merely on the ground that some medical specialists possessing similar skills would resort to similar acts or omissions, as in but that the court must be satisfied that his or their acts or omissions were illogical. In simple terms, the practice must still get support by any of the medical men with the condition that the practice should be considered reasonable by the court. Thus, in applying to the current case, the respondent should be made accountable on the duty of care towards the appellant, as he has reassured her to rely on him when he said that everything is under his control. Nevertheless, he failed to perform his duty of care and breached it for the improper diagnosis. As a general surgeon with experience over 10 years, he shall know and act promptly and reasonably, especially in diagnosing a patient. The standard of care shown by Dr. Strange is not satisfied. He merely acted on his own without getting some other reasonable advice or suggestions from his colleague or anybody that worked in the same field as him in the medical sector. He even denied a suggestions given by a nurse, Raya, about the practice of implying the endotracheal intubation, as it is considered to be unnecessary at the first place. Here, the opinion is considered to be reasonable, as imposing an intubation on an alleged COVID-19 patient is so exaggerated. Applying to the Bolam test, the judgments of a medical practitioner are upheld as long as a person in the same profession as Dr. Strange agrees with them. That being said, Dr. Strange's dismissal of Raya's advice concerns does not appear to be consistent with this, leading to the conclusion that Raya did not make a judgment that a similar individual in the profession would approve. The conditions of appellant could be better than the incident if only Dr. Strange applied his duty of care in diagnosis the appellant carefully. This has led the situation where the appellant had to go through the unnecessary treatment, which is endotracheal intubation, for the careless and mistakes done by the respondent, which is Dr. Strange, on his duty to diagnose at the very first place. Hence, as a medical practitioner, a doctor is required to act under his professional care in accordance with the standard of care for medical negligence.
Medical negligence law has so far been handled traditionally by court, mainly through the principles made by common law. However, there are clear advantages of constructing legislations that are able to clarify the law, particularly on the changes made in establishing the standard of care in medical negligence litigation. So, should Malaysia legislate these principles of law?
Much obliged, my lady. The principles applied in medical negligence based on the traditional method was only emphasized on the circumstances and opinions as to whether the practice is being accepted by body of medical men. However, by imposing a specific legislation in the practice of standard of care in medical negligence, it would be very easy to distinguish as to whether the duty has been breached or not. This is because when a specific litigation has been established, the medical practitioners are provided with some guidelines and outlines and standard to define as to whether the practice is accepted according to the standard given or not. It won't be too vague to define and describe the liability for the cases in the medical negligence. Therefore, I agree with Your Honour, the doctors can only practice in accordance with the standard that been defined under the specific legislation. Last but not least, the respondent is said to be negligent for his breach duty of care to diagnosis towards the appellant and should be made liable for the case of medical negligence. With the above arguments and reasons, we humbly and respectfully ask the court to allow the claim by the appellant on the basis of medical negligence done by the respondent. I shall yield the floor to my learned counsel to proceed with our submission. Much obliged, my lady. I thank the court for its time and indulgence. Thank you.
My lady, my name is Syaza Danisha and I appear as the junior counsel for the appellant, Miss Emma Corella-Stone, whom I will refer to as the appellant throughout this entire submission. With my lady's permission, I will limit my submission to 15 minutes to present my ground. I will deal with the submission points regarding the second issue, that the respondent had been negligent in treating the appellant, Miss Emma, and had caused her to suffer from significant psychiatric illnesses. It can and should be reasonably foreseen by Dr. Strange, the respondent, that his actions would be likely to cause nervous shock to Emma, the appellant, who experienced a gravely traumatic event. My lady, I will first submit that what had been suffered by the appellant is accepted and valid under the law, and secondly, I will submit on that the injuries by the appellant suffered are reasonably foreseeable. I will now move on to highlight my very first point in brief, that what had been suffered by the appellant, reported as historical personality disorder and morbid depression, clearly had satisfied the definition of shock in the legal context.
Counsel, what is shock in the legal context?
Much obliged, my lady. Recognized in the case of Alcock and Chief Constable of South Yorkshire Police, every possible type of mental illnesses, neuroses and personality change that are medically recognized are all regarded as shock or psychiatric illness in law, where these two bears the similar meaning. The term shock developed over time, and now the illnesses are often regarded as psychiatric illness. In this case, highlighted again and again, aside from that the illnesses must be medically recognized Another significant point is that in determining an actual mental illness, there is a need to draw the line against severe sorrow or emotional distress. Strictly, only psychiatric illness could raise liability in court. In our present case, the appellant did not just suffer mere sadness, my lady, grief or sorrow that are of inevitable, even though there are possibilities that these emotions were also felt as sharply and deeply by the appellant, but mental illnesses in this context are greater than those emotions. The illnesses must be first medically acknowledged, and second, must cause further psychiatric damage to the victim. The illnesses suffered by the appellant, the hysterical personality disorder, is categorized under the personality change. Meanwhile, morbid depression is recognized under mental illness. Both are medically recognized even universally. Plus, to support the second subpoint, these illnesses had caused further psychiatric damage to the appellant, to Miss Emma. The facts were clear on that due to the fact that the appellant suffered psychiatric disorders, these had restricted the appellant from functioning properly. Therefore, I wish that this point proves my lady and the court that what she was suffering with fulfilled the shock recognized test, give rise to the respondent's liability in negligence.
Counsel, the law in Alcock stands in which the House of Lords considered whether there was some fair way of identifying where the line should be drawn between those entitled to compensation for psychiatric injury and those who are not. The categories of claimant are just too limited. Should this arbitrary and unfair law in Alcock be reformed?
Much obliged, my lady. The Alcock case recognized the victims as two possible categories, the primary and secondary victims. However, the requirements to succeed as secondary victim are too gratuitous in some way. Particularly on the requirement of there must be proximity between the plaintiff and the accident in terms of time and space, and the requirement that the means of how plaintiff acknowledged the accident. The first one mentioned highlight the importance of being immediate. It requires the plaintiff to present immediately to the scene. The second one mentioned, my lady, similarly impose requirements on the means of how plaintiff acknowledged the accident. If the accident happened to be perceived by third parties such as television, telephone call, then this will cause the whole claim to be invalid. My lady, we are of a view that should the case involve nature of relationship between the primary and secondary that outweighs everything else or which carries heavy natural affection and love, and if this kind of relationship could be proven in the court, such as those of mothers and their children, these two requirements should be neglected. The law should realize that no matter the situation, the natural relationship nearness is far way too salient to be put aside as compared to the irrelevant requirements. We stand with the view that those who could prove the very proximity of relationship with the primary victim should not be subjected to the above mentioned two irrelevant requirements. My lady, now I will proceed to our second but main point in this submission, in proving that there is negligence on part of the respondent because the injuries are reasonably foreseeable even though the damages are more extensive than usual. In reliance to the case of Smith and Leach Brain and Company Limited, the defendants were held liable even though an ordinary man would not have developed cancer as a result to the brain as what happened to Smith's late husband. The injury of cancer was extensive, extended from the initial injury, which is the burn. The principle established was that the tortfeasor is to take the plaintiff as he finds him. The respondent must take the appellant as he found her, similarly in our case. In our present case, the appellant, Miss Emma, appeared to him as a psychiatric illness patient, where she was already diagnosed with OCD and severe anxiety issues. agreed by us that her sufferings caused by the experiences applied by the respondent, which were of hysterical personality disorder and morbid depression, were significantly stemmed from her preconditions that she suffered OCD and anxiety issues. Without her being severely anxious and having the OCD, she would not have suffered the personality disorder and depression, which are totally of a more serious case of mental illnesses. Hence, my lady, we agreed that the defendant's conduct resulted in a much more severe damage to the plaintiff than what is reasonably anticipated by an ordinary man. We could clearly perceive that the appellant's condition fall within the ambit of eggshell skull, because if she was not mentally sick before she experiences the trauma, the damages would not be as much as the two new illnesses diagnosed to her. Truthfully, my lady, these extensive injuries were not foreseeable to ordinary people who are healthier than the appellant, where they did not suffer mental illnesses beforehand just like her. However, I wish to make clear that in Smith and Leach Brain and Co. and Company Limited, the case highlighted that the test in every case is whether the injury was reasonably foreseeable, instead of questioning whether the extent of injury was reasonably foreseeable. There are differences in these two. This is called the eggshell skull rule, where the tortfeasor is also liable to cases where the eggshell skull rule applies. A man is liable to cases which the damages are reasonably foreseeable, but what would amount to the damages he suffered as the result of the damage depends on the victim's constitution or conditions. Now, applying the rule in determining whether the mental trauma was reasonably foreseeable or not, we shall refer to the circumstances of the case. Firstly, in our case, it is I stand corrected, my lady. Firstly, in our case, the respondent knew well that Emma has a serious OCD and severe anxiety issues, as in the facts he once said that hospitalization chances are slim because the appellants would dismiss certainly the idea because of her OCD condition, proving that the illness of the appellant had come to the knowledge of the respondent before the treatment. This rule applies even though the knowledge was not present, but the fact that the respondent having had the knowledge further strengthens the appellant's point that the injury of causing mental illness caused from the trauma is reasonably foreseeable. My lady, secondly, the nurse Raya had prompted the respondent that what he was doing to the appellant was not appropriate, but excessive. When the appellant's condition worsens, the respondent requested the nurses to sedate the appellant, Miss Emma. Hearing this, Raya suggested for Emma to be rolled over and laid on her front. She was confident that this method had impressive effects on balancing patients' oxygen saturation. She said to the respondent's decision to intubate her that it's like driving a Ferrari to go to the shop next door. Where you press the accelerator, you will smash the window. This situation of disagreement of ways in treating her had again proved that the appellant's affected mental condition was reasonably foreseeable because the treatments were excessive. Thirdly, my lady, another point to prove that the mental injury is reasonably foreseeable is that the appellant had regained consciousness before sedated. She struggled to set herself free. It is foreseeable that the quick and reckless act of the respondent in sedating her in her state of struggles to be free is foreseeable to cause a psychiatric illness, because even any reasonable man would be mentally affected with course of being sedated and put into ICU depending on the ventilation machine when everything was done very quickly and when one has even regained consciousness. My lady, one would be very shocked to be unconscious, regained the consciousness, and quickly sedated and put to sleep on ventilator after. Therefore, in the event that the respondent knew that the appellant was a psychiatric patient, thus I stand corrected, plus the nurse impliedly saying that the choice to ventilate her was excessive and that the appellant had gained consciousness and struggled to be free but was forced to be ventilated, which these three resulted in 20 days in the ICU, proved that the mental injury was reasonably foreseeable. The respondent could never claim that the injury was too excessive and further claim that those were in fact not foreseeable because, upholding the eggshell skull rule established in the case of Smith, the respondent should take the victim as she finds him, as he finds her. I stand corrected. We submit the element of injury being reasonable, foreseeable, satisfied.
Counsel, society is beginning to understand psychiatric or mental illness better. Attitudes towards psychiatric illness are changing, thus psychiatric illness is as deserving of the law's protection as physical injury. Are there any policy considerations that state otherwise?
My lady, one obvious policy that rejects the understanding of psychiatric illness in Malaysia is the penalisation of suicide attempts, where repeals aside from amendments are demanded against Section 309 of Malaysian Penal Code that governs this suicide attempt issue. This policy had restricted Malaysia and the judicial system from the move towards a humane society by destigmatizing mental illness and from protecting those who are tested with the illness. My lady, based on the submission, we humbly plead that the respondent had failed to practice the standard of care as a medical practitioner, that the respondent had been negligent to exercise reasonable care, and to award the appellant for the measures that she had suffered.
My lady, if it pleases the Honourable Court, my name is Judge Khairushazwina, together with my co-counsel Fathin Syafifah, appearing on behalf of the respondent, Dr. Stephen Strange. Today we have two grounds to submit, which firstly, the respondent had demonstrated reasonable care as a competent medical practitioner in providing diagnosis and treatment towards the appellant, and the respondent did not reasonably foresee that his treatment would cause the appellant to suffer nervous shock. I would require 15 minutes of the court's time for my submission. My submission today, my lady, concerns with the issue of whether the respondent owed any duty of care towards the appellant for the treatment of endotracheal intubation that was given to her. Firstly, we will enlighten the court on the matter of which standard and duty of care would be applicable to the current case and when it is owed to a patient. Next, we will present to the court which opinion of a medical practitioner should be held valid. And lastly, we will submit the opinion of a judge in regards to medical negligence to show that the respondent owes no duty of care towards the appellant. If it pleases the court, I will proceed with my submissions. My lady, I will present to you the justification for the response towards the first ground of the appeal. In this submission, my lady, we contend that the respondent does not owe any duty of care towards the appellant for the treatment of endotracheal intubation that was given to her. In discussing the issue of which standard and duty of care should be held applicable to the current case, we submit that the principle that was laid in Bolam and Front Hospital Management Committee would be relevant to the current case, as it is also still applicable in Malaysia.
Counsel, I have a question for you. What is a doctor's duty of care and standard of care?
Thank you, Yang Arif, for the question. A doctor's duty of care and standard of care can be seen stipulated in Bolam and Front Hospital Management Committee, which is also the case that introduces the Bolam test. As established by Judge McNair in the said case, the standard of care demanded of a doctor is that for a doctor to act in accordance with the practice accepted as proper by a body of medical men who possess similar skills to the doctor in question. A doctor may escape liability as long as there exists a responsible body of medical opinion that approves the action of the doctor. As for the duty of care, is that when a doctor holds himself as having the required skill and expertise to treat someone that he is said to owe duty of care towards the patient, as further applied in common law courts for the case of Sideway and Board of Governors of the Bethlehem Royal Hospital and the Maudsley Hospital and others. The legal duty of care for doctors can be divided into individual duties, which are duty to warn, to treat, and to diagnose. I will proceed, Arif. As provided under Section 3, Clause 1, Clause A of the Civil Law Act 1956, common law principles are still relevant and applicable in West Malaysia. Hence, the Bolam test can still be applied to the current case concerning the respondent and whether he had carried out his duty of care towards the appellant as a medical practitioner. In regards to the Civil Law Act 1956, which had clearly stated that the common law of England shall be applicable in Malaysia, it can be said that the respondent should still be subjected to the Bolam test. As seen in the case of Bolam and Friend Hospital Management Committee, a duty of care is only owed when a medical practitioner fails to provide reasonable care in applying the Bolam test. The application of Bolam test could be further seen affirmed in the case of Sideway and Board of Governors of the Bethlehem Royal Hospital and the Maudsley Hospital and others, in which it was held that a doctor does not owe duty of care to the patient as long as the treatment was done with reasonable care and accepted medical practice. It could be seen from the facts of the case that the respondent had indeed been providing the appellant with reasonable care and within an accepted medical practice when he decided to ventilate her using the mechanical ventilator, considering the fact that the respondent is also a general surgeon with over 10 years of experience who knows well that mechanical ventilators are crucial life-saving devices. He had provided the appellant with a treatment that he thought would save the appellant from being critically ill, and since the said ventilator is crucial in life-saving device, it shows that the said treatment is indeed within an accepted medical practice. Furthermore, my lady, we submit that the judgment from the case of Chin Kiowis and Government of Malaysia, where it was held that an opinion should be based on the professional standing of the medical practitioner. As a medical practitioner who has been treating patients for 10 years, the respondent could be said to be a professional, and his standing should be regarded as a professional standing of a medical practitioner, considering his experience and knowledge as a doctor. Thus, he had not been negligent and owes no duty of care towards the appellant for the treatment given, even when he had dismissed the opinion given by one of the nurses who was also present during the treatment. My lady, we also would like to submit a statement of Datuk Dr. Haji Hamid Sultan, the Judge of Court of Appeal, in his judgment for the case of Datuk Dr. V. Turaisingam and another and Samarkand Ganapati, in which he stated that since medical science is not a precise science, there are risks connected with doctor's judgment, which must be balanced with the necessary elements. As any other professional, they too learn by trial and error, and courts have taken cognizance of their plight. Hence, from the said statement, we contend that the respondent's immediate decision to give the appellant endotracheal intubation was made due to the critical situation suffered by her. Hence, he owes no duty of care towards the appellant for the treatment provided based on the situation given and his judgment as a doctor of 10 years' experience. In conclusion, my lady, we, on behalf of the respondent, contend that the respondent owed no duty of care towards the appellant for the treatment of endotracheal intubation that was given to her, since the treatment was done with reasonable care and accepted medical practice, as affirmed in the said case before of Sideway and Board of Governors of the Bethlehem Royal Hospital and the Maudsley Hospital and others. A doctor does not owe duty of care to the patient as long as the treatment was done with reasonable care and accepted medical practice.
The Bolam test places a fairly high threshold for a plaintiff to cross in an action for medical negligence, and if the law played two interventionists a role in the field of medical negligence, it will lead to the practice of defensive medicine. So how do you think we could maintain a fair balance between law and medicine in the best interest of the patient whilst giving full encouragement and support to a properly regulated and competent medical profession?
Thank you, Arif, for the question. In addressing my lady's question, I would like to bring the court's attention to a point that was well articulated by Lord Judge Lord Denning in Roe and Ministry of Health, which was also referred to by Datuk Dr. Haji Hamid Sultan, the Judge of Court of Appeal, in giving his judgment for the case of Datuk Dr. Viturai Singham and another and San Markan Ganapati, in which the Lordship observed that every surgical operation is attended by risk. We cannot take the benefits without taking the risk. Every advance in techniques is also attended by risk. Doctors, like the rest of us, have to learn by experience, and experience often teaches us in a hard way. Something goes wrong and shows up a weakness, and then it is put right. Therefore, we contend that in maintaining a fair balance between law and medicine in the best interests of the patient whilst giving full encouragement and support to a properly regulated and competent medical profession, the law must consider that medicine is not a precise science and there are going to be risks and benefits in performing it. However, my lady, the risk must be taken in order to create a better world of advanced science and medicine, and in order to combat new viruses and bacteria that might cause chaos to the world. Therefore, the law must take into consideration the benefit rather than the risk of medicine to the patient. If the issue is regarding a new disease or newly found problems, then the law could take into consideration of that issue and be more lenient towards medicine and try to provide a better solution for both parties involved. However, if the issue is regarding an issue that has been countlessly performed before, then the medical professional involved should be held liable if any misconduct or negligence occurs. One's experience and knowledge must also be taken into consideration in making decisions regarding the matter that involve this type of science. There are plenty more that have yet to be discovered in regards to medical science. Thus, a lot more risk and benefits should be expected from this particular type of science. Hence, the support and encouragement from the law are really needed in developing the said science, because if not, that the medical professional would be hesitant in performing their duties.
Counsel, medical negligence law has so far been handled traditionally by court, mainly through the principle made by common law. However, there are clear advantages of constructing legislations that are able to clarify the law, particularly on the changes made in establishing the standard of care in medical negligence litigation. Should Malaysia legislate this principle of law?
Thank you once again, my lady, for the question. In answering the question of whether Malaysia should legislate these principles of law, if I may, I would like to submit another point that was also referred to by Datuk Dr. Haji Hamid Sultan, the Judge of Court of Appeal, in giving out his judgment for the case of Datuk Dr. Viturai Singham and another and San Markan Ganapati. Another point is that he stated that the law on medical negligence as a starting point could be stated as set out in the federal court in the case of Kau, Nanseng and Nagama, where the federal judge Saleh Abbas, as he then was, observed that the law on medical negligence is clear enough, but its application is often difficult as facts and circumstances are not the same in each case, and so must vary from case to case. From this statement, my lady, we could conclude that the case of medical negligence could vary depending on the issue and the patient itself. Thus, we contend that it is better for us to keep the option of which test should be applied in a certain case open, since the law provided by common law is already clear enough to be used. If we were to legislate these principles of law, it may restrict its application and it may not fit certain cases, since the facts and circumstances are not the same in each case. Thus, the application for the new legislative principles of law, if it were to be made, might bring unfairness towards some case. Thus, we contend that Malaysia should not legislate these principles of law. However, a mere improvement of these principles of law as seen in some of the decided case would be appreciated. Therefore, in conclusion, we, on behalf of the respondent, once again contend that the respondent owed no duty of care towards the appellant for the treatment of endotracheal intubation that was given to her, since the treatment was done with reasonable care and accepted medical practice. In light of this submission, my lady, we humbly pray to the court to declare that the respondent had offered from advice of risk, diagnosis and treatment to the appellant, and that the respondent had demonstrated reasonable care as a competent medical practitioner in providing giving diagnosis and treatment towards the appellant. Thus, I thank the court for its time and indulgence.
My lady, may it pleases this honourable court, my name is Fathin Syafifah, Junior Counsel, together with my lead counsel, Judge Khairushazwina, representing the respondent, Dr. Stephen Strange. My lady, I have one ground of contention to present in our submission today. My ground of contention is that the respondent did not reasonably foresee that his treatment would cause the appellant to suffer nervous shock. I shall require 15 minutes of the court's time for my submission. My lady, if there is no further inquiry, may I proceed to our ground of submission? Much obliged, my lady. We submit that the respondent did not reasonably foresee that his treatment would cause the appellant to suffer nervous shock. The learned judge from trial court Sherlock Judge stated that there is a real need for the law to place some limitation on the extent of admissible nervous shock claims. In pursuant of this matter, the definition of nervous shock or psychiatric illness is provided by Lord Ackner from the case of Alcock and Chief Constable of South Yorkshire Police as a shock in the course of action involves sudden appreciation by sight or sound of a horrifying event, which violently agitates the mind. To claim psychiatric illness, the illness must be reasonably foreseeable. The nervous shock suffered by the appellant does not fulfill the definition of shock provided in Alcock because the damages in result of the cause of the action by the respondent was reasonably unforeseeable. This is because the respondent could not foresee that the appellant's sudden consciousness at the time of the treatment, given the nature of the appellant was into, which is she was into a hypoxic state during the treatment.
Counsel, may I ask a question? What is shock in the legal context?
Much obliged, my lady, for your anticipation. Nervous shock is a psychiatric or mental injury inflicted upon a person by intentional or negligent actions or omissions of another. Nervous shock resulted from the sudden shock of witnessing or participating in a special single event. The courts will draw a distinction between claims in respect of medically nervous shock and claims for mere grief, sorrow and distress. Under the legal context, shock suffered by the claimant must extend beyond grief or emotional distress to recognized mental illness such as anxiety, neurosis or reactive depression. If I may invite the court to refer to the case of White and Chief Constable of South Yorkshire Police, the nervous shock includes post-traumatic stress disorder, PTSD, organic depression and a change of personality or pathological grief disorder. My lady, are there any other inquiry?
Pursuant to your response, the categories of claimant in Alcock and Chief Constable of South Yorkshire Police are just too limited. Should this arbitrary and unfair law in Alcock be reformed?
Much obliged, my lady, for pointing that out. Indeed, my lady, we believe that the unfair law in Alcock should be reformed, particularly on the requirement of close ties and of love and affection between a secondary victim and the immediate victim. The legislation should provide that the requirement of close relationship could be satisfied by the existence of such a relationship either at the time of the accident or at the onset of the claimant's nervous shock. And this is not only limited to statutory fixed list or relationships such as familial or spousal relationships. My lady, if there is no further inquiry from the bench, I may invite the court back to my submission. Coming back to my submission, the principle of reasonably foreseeable was illustrated in the case of Bohill and Young, where it was ruled that a person has a duty to act with reasonable care to avoid the risk of damage to others, which can reasonably be affected if he fails to do so. Nervous shock claims can be brought to the court that they have a genuine psychiatric illness arising from a circumstance that the defendant ought to have foreseen to be capable of causing a person to suffer a recognizable psychiatric illness if reasonable care were not taken. However, Lord Porter in Bohill and Young Lord Porter in Bohill and Young also stated that it is not every emotional disturbance or every shock which should have been foreseen. Thus, it is affirmed that that to claim psychiatric illness, one should prove that the shock was reasonably foreseeable. The respondent had acted in reasonable care during the emergency treatment. When the appellant was still unconscious, he quickly monitored her blood pressure, heart rate and pulse oxygen saturation before he intubated the appellant. However, during the preparation to perform the intubation, the appellant suddenly gained consciousness and started to struggle. The respondent did not continue to intubate her. Instead, he asked the nurses to sedate her. The respondent could not reasonably foresee that the appellant would suddenly gain consciousness, and it is not unforeseeable as it would cause a significant effect on her mental condition when she saw herself in this isolation treatment room. My lady, I have to stress that the appellant was unconscious and the respondent was preparing to intubate her. The sudden consciousness was totally unpredictable because she was in hypoxic state. Thus, her reaction to intubation, which caused her psychiatric illness, was unforeseeable. Furthermore, the appellant had pre-existing psychiatric conditions which made her refuse to be treated. There are no reasonable circumstances that the respondent should have anticipated that the treatment would cause a shock to the appellant. Even though the respondent was well informed that the appellant suffered severe OCD and anxiety disorder, it is immaterial at the time of the emergency because the appellant was in a critical condition which is unpredictable.
Counsel, as we know, society is beginning to understand psychiatric or mental illness better. Attitudes towards psychiatric illness are changing. Thus, psychiatric illness is as deserving of the law's protection as physical injury. Are there any policy considerations that state otherwise?
Much obliged, my lady, for your anticipation. We submit that the only policy in my knowledge that did not protect psychiatric illness is Section 309 of the Penal Code, whereas whoever attempts to commit suicide is liable, if liable, can be punished with imprisonment for a term that may extend to 1 year or fine or both. Even the Indian Penal Code, which is in pari materia with the Malaysian Penal Code, repealed the suicide attempt as a criminal offence in 1961. Yet, in Malaysia, the attempt of suicide is yet to be decriminalised. If there are no more inquiry, may I proceed to my submission? Much obliged, my lady. Coming back to my submission, the appellant's reaction to the endotracheal intubation could have not been foreseen given the pre-existing mental illness suffered by the appellant. In considering whether a duty of care is owed to have foreseen as a reasonable person, the Court of Appeal in Hamburg and Stoke provides a liberal test whereby the plaintiff was required to establish that his or her psychiatric illness was a reasonably foreseeable consequence of the defendant's conduct. In determining the reasonable foresight test, the type of damage suffered by the appellant was the psychological effects from the intubation. Nonetheless, the main distress was caused by the appellant's sudden regain of consciousness and not from the endotracheal intubation. It is important to note that the intubation continued when she was already sedated and not during her sudden consciousness. The respondent had acted in a reasonable care to reduce the risk of damage during the emergency treatment. Not only that, the appellant was suspected as a COVID-19 patient, as a new virus in which is still being studied by the researchers, and not only that, there are so many variants of the virus which make the situation become complicated. The reaction of the appellant is hence unpredictable. Pursuantly, Lord Bridge in McLaughlin and O'Brien provides that in determining what was reasonably foreseeable, the judge could either receive the evidence of psychiatrists as to the degree of probability that the particular cause would have a particular effect, or relying on his own opinion of the operation of cause and effect in psychiatric medicine as fairly representative psychiatric of that educated layman. The judge should treat himself as the reasonable man and form his own view from the primary facts as to whether the proven chain of cause and effect was reasonably foreseeable. Lord Bridge also stressed that the judges must be informed by modern medical thinking. My lady, the respondent had acted according to the standard of care accepted by the responsible body of medical practitioners. The psychiatric illness was unforeseen as the intubation was a normal practice for the doctors to be conducted in cases where patients suddenly deteriorate. Not only that, the respondent stopped the intubation when the appellant suddenly regained her consciousness and continued after she was sedated. Thus, it is unforeseen that the appellant would suffer psychiatric illness from the intubation. My lady, the appellant already suffered pre-existing psychiatric conditions before she was treated by the respondent. She suffered from obsessive compulsive disorder, OCD, and severe anxiety issues, which were worsened by the spike of COVID-19 cases. The appellant may suffer the significant psychiatric illness because of her excessive fear of contamination and infection. The causes of the psychiatric illness are complex and have lots of contributing factors, especially the surroundings and life of the appellant itself. My lady, she was already extremely anxious about the current ongoing pandemic. It was a fact that she would wash her hands with antibacterial soap every 50 minutes until her hands were extremely dry and always bleeding. She always wear the N90 mask almost all of the time, even when she goes to bed. In that condition, hospital would be the last place she would go due to her fear of the virus. However, the appellant suddenly regained her consciousness in the middle of a treatment at the hospital. Thus, it is reasonable to say that it triggered his mental conditions greatly. It is unjustifiable to say that the intubation was the cause of her psychiatric illness. This is because when she regained her consciousness, the intubation stopped for a while and she was sedated. Only then the intubation was conducted. Thus, my lady, the nervous shock suffered by the appellant after the treatment was not due to action by the respondent during the intubation, but most likely due to her pre-existing mental conditions. Lastly, my lady, medical science has conferred great benefits on mankind, but these benefits are attended by considerable risks. Every surgical operation, every treatment is attended by risk. We cannot take the benefits without taking the risk. Every advance in technique is also accompanied by risk. Doctors, like the rest of us, have to learn by experience, and experience often teaches in a hard way. Sometimes goes wrong and sometimes it will show a weakness. But at the end of the day, it will be put right. We cannot hold every doctor accountable just because they are doing their job. My lady, if I can be no further assistance to the court, that shall conclude the respondent submission. And in light of this submission, we humbly pray to the court that to declare that the psychiatric illness that the appellant suffered after she was treated by the respondent was not foreseeable. I thank the court for its time and indulgence, much obliged, and may it please the court.